Hey y'all, Rob here with ATX Legal, and today I'm going to talk a little bit about the parole review process. And this is the second part of a three-part series on parole. The first one was on just parole eligibility, and I might refer to some terms that don't make sense in this video to you. If there is a term like discretionary mandatory supervision, 3G offenses, if you don't know what those mean, you might refer to the previous video that's on my YouTube channel. And first, I'm just going to talk a little bit about the parole review process. These replaced parole hearings. You might have this idea in your head from maybe Shawshank Redemption, where the inmate is sitting there in front of a parole board and they stamp his file. That doesn't really happen anymore. It's less personable than that now. It happens with documents and paper. The inmate doesn't have to be there. And it's just less formal and less personable than it used to be. The panel is not required to give an interview, but they can if requested by a family member or an attorney. Anyone who's not a family member must be an attorney if they're representing an inmate in parole. It can't just be a priest, a minister, or someone else you know that's a friend of the family. And the first hearing will happen when an inmate is first eligible for parole, and for that determination, check out my last video. But once that first hearing happens, the reviews typically happen on an annual basis. Now, there are some exceptions to that. 3G offenses, which are more serious offenses, can be up to 5 years. And if an inmate is on disciplinary action in the prison, then they can extend that review period indefinitely. Now, one question I get is, how can family members help when a person is up for parole? And the way that family members typically help is with a parole packet. Now, a parole packet is a series of letters or other supporting documents that tend to show that the inmate is either rehabilitated or, more importantly, that they have a good system of support once they get out. Now, the Parole Board has certain guidelines that they suggest be included in these letters, and they're helpful to look at if you are writing a support letter for an inmate. Now, these factors that they suggest are you want to indicate that he has a support system when he gets out, that he has a place of residence, transportation, potential employment is good, and if applicable, maybe set up some treatment programs that he can get into as soon as he is released. And these packets can be very helpful, but keep in mind they don't really want to see an overwhelming stack of paperwork. You don't necessarily want to send in 30 letters. It's best to have 2 or 3 really precise and well thought out letters that the parole board can read, because chances are they're not even going to get to the 5th, 6th, or 7th letter. You're going to want to keep it more concise, but just well thought out and supported with evidence. And in addition to those letters, they're going to want to see a release plan. So where is the inmate going to go when he is released? Is he going to go back and live with his parents, with his wife, girlfriend, boyfriend? Whatever support he has in place and whatever his plan is once he is released, the board does want to hear about that. And one thing about the packet you put together, if you do those at the very first parole review, those letters stay in the packet for future reviews. So the best time to do it is at that very first parole review, if you want to hire an attorney for that one only, because then when a subsequent review happens in a year, 2 years, whenever, everything will be there for the parole board to review. So how does the board make its decision? So they have some factors that they have to look at, and they can't really look outside of those factors. And those are listed on the parole board's website, and those are the seriousness of the offense. So each offense is put into a category from L for low, M for medium, H for high, and then up to H plus for the most serious offenses. So that's one of the factors they look at. Second is letters of support, so that packet we talked about. Third is the sentence length and the amount of time already served. The longer time they've had in, the more likely they are to be paroled. Criminal history and other arrests, and whether they've been on probation and parole before. Number of prison incarcerations. They look back all the way to their juvenile history, and then they look at the behavior in jail. So have they been participating in classes, jobs, things like that while in custody. They also look at the offender's age at the time of the offense and their current age as one of their risk factors. And when the board does make a decision, it's not a simple yes or no. They can release when eligible, which means as soon as he processes the paperwork. That's basically as close as you can get to a straight up yes. They could say release at a certain date, or they could say release when he's completed certain classes, rehabilitation classes in custody. The classic example of this is Safe P, which is a DWI program that's in custody. It can be 6 months long. It can be longer, and you can wait for a bed. So you might look at that yes answer and say, hey, I'm getting released, when in fact you still have 6, 7, 9 months left in custody to do that program before you're released. So bittersweet, but there are different types of release. It's not simply yes or no. And if the answer is a no, then they have several options there as well. It can be no with another review scheduled in a year. For 3G offenses, it can be no with another setting up to 5 years from now. Or there can be an SA, which is serve all. That means for serious offenses, they can say there's not going to be another review. This person's going to serve the rest of their sentence. And for that SA, they will get another review when they're eligible for discretionary mandatory supervision. And for more information about that, check out my previous video. Lastly, this is a question that I get from a lot of people. Do I need to hire an attorney for this process? And of course, it depends on everyone's situation. The Parole Board does release statistics, and they do show that inmates who hire an attorney do tend to be released at a higher frequency than inmates who don't. That could be causation, it could be a lot of factors, but that's just what the statistics say. If there are some factors, some mitigating factors that would suggest that a person is ready to be released, it does help to have an attorney to bring those factors to the front of the Parole Board's consciousness and let them see those factors for themselves. An attorney might be better at presenting those facts to a parole board than the family, who doesn't really know what the parole board is looking for. And at the end of the day, an attorney is not going to be able to guarantee you that your loved one is going to be released. It's just something that we can't do. So we have to look at statistics and probabilities, and just on average, you're going to have a better chance with an attorney. For a lot of people, those time spent in jail, those years you spend, you can't get those back. So it is worth it, even on a probability that you can get released earlier. It is going to be worth it for a lot of people, but that's just the decision that you're going to have to make for yourself or for your loved one. Of course, none of this is legal advice. It's all for educational purposes only. But if you do want legal advice on your issue, if you have a loved one who's coming up for parole, you can give us a call or visit us at atx.legal.